This is a story that illustrates a common reason why family law lawyers report to us: failing to obtain full disclosure from their client's ex-spouse before settling a claim. In this file, a lawyer acted for a husband after the breakdown of his long-term marriage. A separation agreement was entered into in which the parties agreed to a division of assets. The lawyer had accepted the husband's assertion that his wife's handwritten list of his assets and debts was accurate disclosure. The lawyer did not ask the client any follow-up questions, nor did she make a note confirming the husband's instructions to proceed based on the handwritten list. About 6 months later, the husband contacted the lawyer advising that he had learned that his ex-wife had received a large award from a motor vehicle accident up in Whistler. Although the lawyer was aware that the wife was involved in this litigation, she had not made any inquiries regarding a pending settlement, and in particular, any wage loss that may have formed part of a settlement. This was important, as the lost income portion of the settlement may have formed part of the family property. After retaining new counsel, the husband also learned that his ex had listed a pre-settlement lawsuit loan as part of his debts in the separation agreement, listed a debt to his disability insurer that was never paid back, and listed credit card debts that did not exist. The husband applied to set aside the separation agreement on the basis of unfairness and lack of disclosure, but the action settled when he learned that his ex had disposed of her settlement funds and had few remaining assets. He then made a claim against his lawyer, and we ended up paying a 6-figure settlement to settle the malpractice claim. The lawyer had to pay her deductible and is facing 5 years of surcharges. This case illustrates how important it is for a family law lawyer to make inquiries when there's inadequate financial disclosure. And if your client gives you instructions to settle without satisfactory disclosure, warn your client in writing of the risks as set out by Madam Justice Nielsen in Newton versus Marsban. So what can you do? Protect your client and yourself by following the guidance of the Supreme Court.